What's the meaning of life?
Yeah.
Yeah.
Right.
You're not going to get any answers here.
What's the meaning of that? How many dead people have you dealt with?
Good amount.
Yeah.
Any ghosts come back?
Ooh, that's a great question.
They've been quiet.
From the top?
From the top.
From the top. Welcome to 6-Minute Increments, where we're looking at business and legal issues. Today, we are joined by a very esteemed colleague of ours, our very own Jason Livingston.
Welcome.
Which I'm thankful that you're here after being in a little bit of mourning as a trust and estates attorney, since this is Rochester. Jay is a huge Bills fan,
Right.
but he is here today.
Yeah. I was told this wasn't going to be brought up today.
I had to. It had to be there. That's
Yeah.
the relationship we've had after 20 years. But Jason, great to have you here. Why don't you tell us a little bit about what you actually do?
Sure. So I've focused solely on the area of trust and estates law since the beginning of my career. In my 20th year now, so it's been
doing
a
it a
long
while.
history. Yeah.
Yeah.
So that can encapsulate a lot of different things, whether it's traditional, straightforward estate planning, which would be, will, power of attorney, healthcare proxies, more complex trusts, whether that's for estate tax planning, reducing estate taxes, avoiding estate taxes, or asset protection, whether it's long-term care planning, trusts, or other things like that.
What's the percentage of people that know the difference between a power of attorney and a living will and healthcare proxy? You got 20
It
years
varies.
of data.
It varies. I think there's more nuances that they don't understand about the two. And that, they might understand that one is for healthcare, at least a healthcare proxy, and the power of attorney. They may or may not be familiar with the fact that it's for financial, uses. But there's a lot of other nuances they don't understand about those. So that's what, we try and help guide them through.
How often do you find that when the person tries to use a power of attorney, like, why don't you explain a little bit about what a power of attorney does, how somebody
Sure.
uses that?
Why you would want one?
Why do you
Yeah.
want one?
I think everyone should have one, especially,
I agree.
Yeah, it's very important because what it does is it allows you to appoint an agent or multiple agents that can essentially stand in your shoes for any real financial decisions that you might be able to make for yourself. But if you're otherwise incapable of making those decisions for whatever reason, then your power of attorney or your agents named in the power of attorney can come forward and act on your behalf.
What's a real life scenario where somebody didn't have one and it was a disaster?
Sure, it can happen in a lot of scenarios, where if somebody gets to a point where they're either incapacitated unexpectedly, or if it's over time and they start having some cognitive decline and now they no longer have the capacity to make their own decisions. If you don't have a power of attorney, your hands are tied. You can't access their funds. You can't help pay their bills, sell their assets, like if they're needing to sell a house or something else.
Yeah, Jay helped my grandparents. My grandfather had some cognitive decline. We had to have the power of attorney. That helped with a lot of the transactions that went on. But it's a critical document to have, and they came and worked with Jay.
A question I have is, a lot of people, when they're in cognitive decline, they're in denial about being in cognitive decline.
Sure.
So I have two questions. When somebody is in that state and they're trying to do a will and you see that they're, they don't have their full mental cognitive function, or family members are trying to exert their power of attorney and the person is saying, no, I don't need that. I'm fine. I can make my own decisions. What do you do in that situation?
Yeah, I mean, it's not always a clear black line, issue that you have to evaluate it, because if somebody's in the beginning stages of decline and starting to, is doubting it or is, doesn't want to accept it, if they still have capacity, they might still be able to sign some new documents like a will. Or if they still have capacity, although it's starting to wane a little bit, they can still sign a power of attorney, or remove or take away someone's right as a power of attorney. Okay, so you can revoke it if you want to as well. However, if they get to that point where it's really clear that they don't have that cognitive ability any longer, and it has declined past that point, well, then you just have to, work with the agents and make sure that they're understanding the situation and, looking after the best interests of their principal.
Now, this is cheating because I know part
Yeah.
of the answer to this, but you talk about capacity. So, how are you? I think for the average person, they have in their head what that means. And so sometimes they'll argue, well, I don't think mom had capacity because I've seen this deterioration. Could you explain a little bit more about what you mean by capacity?
Like, is it they're putting socks in the dishwasher? Or,
or they've got an
pine cones in their
F-250 versus an
purse?
F-150, what kind of towing capacity?
Yeah. So it depends really on what kind of document you're talking about. Whether they're signing a power of attorney versus a will are two different thresholds for cognitive ability. Actually, the threshold for signing a will is less than that of a power of attorney. A power of attorney is a contract, so that threshold is actually a little higher. Whereas with a will, you really just have to have a lucid moment. And how do you determine that? That's really sometimes part of the job as an estate planning attorney is working with the client, asking questions, almost quizzing them along the way if there is a question, first of all, or if their capacity is that question, and trying to determine as their attorney, as the witness to the will, do you feel that they're know the natural objects of their bounty? That's one thing, okay, which is who are they leaving their assets to in their will? Do they know who their children are, their grandchildren, their spouse, right? That's the natural objects of their bounty, per se. Another is, do they understand what assets they have? Do they understand that they might have, a few $100,000 of assets in a house, or maybe a few $1 million of wealth and other assets, or a business? Because they really need to have at least some broad understanding, not down to the penny or down to the dollar, but a broad understanding of what it is they're conveying or within their will.
Now, I really want to ask you if you've ever been in a meeting where somebody ruined your capacity questions and started answering them on behalf of the client.
I will
we won't get
overrule
into
that question.
We'll
It's only
overrule
happened
that question.
once.
It happened
Just
once.
once.
With a lawyer, I heard.
Yeah.
Out of curiosity, how did you get into this in the first place? I mean, you've been doing this now for 20 years. I think one of the things that we try to highlight for clients and people is the human side of being a lawyer. What drove you into doing this in the first place?
Do you have any regrets?
Yeah. So
She means about the job.
No, not about today. No, I think that what really started me down the path of estate planning was some of my prior experience with financial planning. So, as an estate planning attorney, we work with clients on their finances and how their assets are passed down to the next generation. So we have to have a good understanding of what their financial structure is, individual structures are. And so I had kind of a prior exposure to financial planning through my father, who was a financial advisor for many years before I went to law school. I also even, started and looked at maybe going down the path of being a financial planner myself.
Which is pretty common. A lot of trust and estates lawyers do kind of go into both realms.
I decided ultimately to go down the path of entering, applying for and going to law school. And so when I was there, you're taking all of these core classes, for constitutional law, contract law, whatever it is. And then once I was able to start taking my electives, I realized, well, I'm going to start taking some estate planning courses and some estate tax courses. And I found that very interesting. And then I realized that was because it was overlapping with my prior exposure and interest in financial planning. So the two just kind of wove together.
And now I know a lot of people will look at this and they'll hear estate planning and then they'll hear about Medicaid planning. Sure. What's that?
Yeah, Medicaid planning is different, and it comes in a couple different forms. It's in large part it's an asset protection planning. I can go into the details of what is Medicaid planning is really protecting or trying to come up with a plan for paying for long-term care expenses as somebody, ages and goes into levels of care that they may need, whether that's aides coming to the home for a certain number of hours per day or per week, whether that's then transitioning into a senior living community or senior living housing or assisted living or memory care, and then ultimately whether or not they have to go into that highest level of skilled care.
What don't people think about when you go through your day? What's the number one thing that over all of these years of doing this, you would say has been the most consistent thing people don't think about?
When it comes to their estate plan,
Yep.
I think one trap that people or clients fall into frequently is when they say, hey, I have a will, I have a power of attorney, I think I have a healthcare proxy. We did them 20 years ago, don't know where they are, don't know what they say, but I've got them, so I'm good. And they kind of just rely on the fact that since they have something in place, it's got to be good enough. And, to that extent, when I'm working with clients, I always want to say, well, let's at least look at those. If you want me to, I will review those and look at them to make sure they have enough authority, in the power of attorney, because not all are drafted the same. Does it have enough authority within the document so that if it comes time where someone needs to use it, that they'll be able to execute and make the decisions that they'll need to make? And then two, if it's their will or their healthcare proxy, does it still name the same people that they want? Have things changed over the years? Do they know where their original documents are? Because, I will have clients come to me and say, sure, I have a will. I don't know where it is. Or they may have a copy of it, but they don't know where the original is. And really, we need that original at the time when the time comes. And without that original, having a copy alone is going to be difficult to move forward with.
I have a question because a lot of the show is discussing legal fees, how they're
Sure.
determined. So, when people go to use legal services, they're not surprised. Why would somebody use someone such as yourself rather than LegalZoom? And is a service like LegalZoom really cheaper, quote unquote, than using an attorney? What are your thoughts on that?
Sure. I mean, I haven't priced out what LegalZoom is charging. It's an a la carte structure. So whether you want to get one document or all of the documents, but what you're paying for and what you're getting are two different things, right? You're getting a self kind of guided tour through filling out a form document that they'll provide you. You're really not getting any advice or guidance along the way. You're not getting a lot of, discussion about what your possible options are. What are you not thinking of? What pitfalls might you be running into by, making this decision versus another? You're really just guiding yourself through it. And if you don't have, that background knowledge base or don't want to go out and learn it all on your own, then just following the guided prompts may not be the best approach. But when it comes to the legal fees from an estate planning attorney, we try and, offer more or less we don't try to have any surprises, if that makes sense. So in large part, when it comes to the estate planning side, preparing wills, preparing powers of attorney, preparing trusts, things like that, we oftentimes, not always, but oftentimes work kind of on a flat fee quoted structure. And so I always try to give my clients an anticipated fee range during that first meeting, that first interaction, because usually during that first meeting, I've gathered enough information as to what type of estate plan is going to work for them, how straightforward or how complex that estate plan is going to be. And once I have that insight and information, I can start, I can give an idea of what the time involved will be and ultimately what the flat fee quoted range would be.
I mean, my experience too, I think to plug a little bit for the estate planner and some counsel is it's not the estate plan that usually you really need help with as much as what happens when somebody passes. And if you don't have somebody that you can turn to, I mean, the estate administration process can be extremely overwhelming. Having had my family recently go through it, and we worked with Jay, how do you, as you shift and the individual who you wrote the will for has now passed away, how do you prep families to deal with administering the estate? And how often are the families coming back to you if you did mom or dad, or heaven forbid, your spouses or those wills? How often are you helping them through the process, and what do you see there?
Yeah, I think it's pretty routine. It's pretty common. I mean, I've now been practicing 20 years, so I've now had clients long enough where they're starting, the clients that I've helped build their estate plans a decade or two ago are starting to now get to the point where they're passing, and now I'm working with their surviving spouse or their children on the administrative side. It is pretty common that if an estate plan was done by our office, that the family does choose to stay with our office to guide them through the estate administration. However, I tell them, and I would tell anyone, just because an attorney prepared the will doesn't mean you have to use that attorney. You don't have to use our office if you don't want to, if you feel more comfortable going somewhere else. But in the same regard, if your parents' or spouse's will was prepared by another attorney, don't feel like you're required to use them either. You can move around to someone if you feel more comfortable using somebody else. But to help guide them through that process, I usually at least tell them, hey, it's going to be a process. There's going to be several steps. And we're going to, our job as the attorneys, as your lawyers, are to help guide you through those steps.
Does LegalZoom do that?
No, that's
No,
not
they
going
don't
to
do
help.
that.
Yeah,
No, they
that's
don't.
not
They
going to
don't.
do
There's
anything.
no
Yeah.
humans.
Yeah.
Right.
Just
Yep.
self-guided tour
Right.
through an incredibly
Yeah.
complicated year-long plus process.
Yeah, so there's kind of like a life cycle for an estate administration. A typical estate administration, a lot of people ask, what is the timeline? How long is this going to take? Usually say that the typical estate administration is going to be, in New York anyways, at least 7 months, up to maybe 9 months, give or take. And the reason for the 7 months is because there's a state statutory creditor period. So it just protects the executor, it protects the estate to leave it open for 7 months before you pay everything out and close it down. Now, before that 7 months is up, doesn't mean you're not doing anything, that you're just sitting on your hands waiting for that 7 month period to pass. During that time is when you're doing everything. You're clearing out the house and selling it if that's what you want to do. You're cashing out, investment accounts and consolidating them, paying off known debts or creditors and things like that. I always say it's kind of the process of estate administration, at least for an executor and for the lawyers assisting them, is kind of front loaded in the first month or two. And then there's kind of a lull between the next 4 or 5 months. And then when you start getting closer to that 7 month creditor window or month 8, that's when you're, re-engaging and doing the final paperwork to pay everything out and officially close the estate.
I don't want to eat up too much more of your time, but why don't you tell us a little bit about, because the other part that you deal with and people I think often have questions is regarding what is a trust? Like,
Sure.
why
yeah.
have a trust? What
Yep.
do these things do?
Why should we trust a trust?
Why should we trust a trust? Trust in me?
Funny because the concept of a trust took me a little while in law school to really get comfortable with myself. So I can certainly understand, clients that don't deal with it on a day-to-day basis, wondering what exactly does it mean? Really, when it boils down to it, what a trust is it's a separate legal entity formed on paper, right? It is a document, 10 pages, 20 pages, whatever it is. It's a legal document that once it's signed by the various parties to the trust, then it is a legally created entity. Okay. And from the corporate side, Brett, I oftentimes analogize it to an LLC.
They're very similar.
Very similar. An LLC is a legal entity that's formed by paper, but once it exists, it is now an entity that can do several things. It can own an asset. It can buy an asset. It can invest an asset. It can sell an asset. Just like an LLC can do all of those things, so can a trust. A trust does own assets. It can invest assets and then ultimately buy or sell assets within the trust. But then, unlike more like an LLC, the trust has that kind of ultimate payout provisions in there, where it ultimately will, terminate and pay out to its intended beneficiaries. So I will say, a trust is really like acts a lot like a will, but is set up while you're alive and is funded while you're alive. Unlike a will, which is the reverse. A will is a legal document on paper, but while you're alive, it's really just a dormant document. It doesn't have any authority or true effect while someone's alive, and that doesn't get triggered until after somebody passes away. Then the will comes into effect and manages those assets. A trust can be signed while you're alive, own assets while you're alive, and then have provisions to be paid out upon your death. Now, I should mention too, though, a trust can also be embedded within a will. So you can have trusts that are created and funded while you're alive. You can also have trusts that are embedded within a document that doesn't get triggered and created until after death.
Why would somebody want to trust? Like
Yeah.
what common
Kids.
circumstances?
Exactly, kids. So, if you're...
Mine's got a trust.
Yeah,
Mine
Little
doesn't.
kids.
yeah.
Well, your kids are old now.
Yeah.
Yeah, but if you have a right. So, if you're a younger family, minor children, young children, your two main motivators for getting your estate plan in place is one is usually the guardian, who is going to be guardian the children if something happens to both parents. But the other is really asset management. A minor, one can't inherit, a large sum of money if the parents passed away while they were still young. But also, if you don't have a trust structure set up within your will to accept and manage the assets for younger beneficiaries, they will then ultimately get it at a younger age, like 21. And depending on the level of assets and wealth, that might not always be a good thing. So it's very common that when we're working with families with younger children, that we always set up a trust within their will for those minor children. And typically, those trusts last through until they're a little older, whether it's 25 or 30 or sometimes 35. Really,
You know who doesn't assist you with that? LegalZoom.
But a fun thing that I think is out there that a lot of people don't know about, pet trusts. Talk about
trust,
that.
Yeah, sure. We can talk about
I
that.
should set one up
You
for
need
mine.
one of those.
You need one, right?
You've
Yeah.
got a lot of pets.
I have two little ones at home.
I guess so. Legally speaking, you cannot set up a trust for a non-living person, okay, in New York State, unless you use the one provision under the New York State Code that allows for trust to be set up for pets. And yes, so you can set up a trust for a pet, whether it's in your will, or you could set up a trust while you're alive and fund it while you're alive, although almost all of them that I've ever done have been within a will. But essentially, it can set up a structure so that the trust was created after the caregiver, the client passes away, gets funded with whatever dollar amount that they want to fund in there, reasonable dollar amount, and then they can name a caregiver for the pets. They can name a trustee to manage the money on behalf of the pets. It can be the same person. It can be different people. But then those funds are there because, really, if you think about it, if you're asking someone to care for your pet should you pass away, you're also asking them to take on the financial responsibility for
Kibbles
that.
aren't cheap,
Yeah.
No.
You better put a trust together.
Yeah. Or
especially the kind
Pet
I buy.
bills. Oh,
vet
my
bills.
Lord.
Right.
If you're talking about exotic animals that live longer,
For exotic pet foods.
or more expensive like horses. So, those costs could add up over time. And so if you don't also give your caregiver some type of financial assistance ahead of time, you're also asking them to take on that responsibility.
Or the animal goes somewhere,
Yeah.
We want to be respectful of your time.
Yes.
We really appreciate you coming here today. As always, we try to plug our own marketing these days.
Please like, share, and subscribe. We would appreciate it.
Share with your friends,
Share with your enemies.
everybody.
Sharing
Thank
is
you.
caring.
Sharing is caring. Thank you very much,
All right.
Jay.
Thank you both.